Tonight's case offers a revealing look at how courtroom procedure, inmate conduct, 5, and personal accountability intersect inside the criminal justice system. As a defendant pleads guilty to multiple assault charges stemming from incidents inside a county jail, the exchange quickly moves beyond legal formalities and into questions about conflict, provocation, and responsibility. While emotions and allegations of verbal abuse emerge throughout the hearing, the court's focus remains on one central issue: whether the defendant knowingly committed acts of violence. As you watch, consider how much context should matter when courts evaluate actions that occur in high-pressure environments like correctional facilities.
Your Honor, may I?
Oh, he's doing good. Go ahead. So when he said that, I put the sugar ray on him, and here I am, Judge Simpson. Walter Peters.
All right. I have before me in these two cases plea forms that indicate that the defendant is going to be pleading to two charges of assault and/or assault and battery.
That's correct, Your Honor.
And that's as charged, I think.
Correct, Your Honor. There is an agreement or a recommendation of a sentence to time served.
Understanding I can't impose that now because these would be victims' rights.
Understood, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth? No.
Yes.
State your name, please.
Walter Peters.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to two charges of assault and/or assault and battery.
Yes.
And that? All right. Are you having a problem hearing me at all?
No, sir.
Okay. All right. If you do, let me know. Okay. Those are misdemeanors, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty
Yes.
to the charge of assault and/or assault and battery contained in the case ending in 0025. How do you plead?
Guilty.
To that same charge as contained in the case ending in 0322. How do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today, which is really nothing?
No.
Well, what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
All right. And also because you believe that you are indeed guilty of these offenses?
Yes.
Starting in the case ending in 0025, sir, on the date of November 2nd, 2025, at the location of 2201 Hogback Road, that being the Washington County Jail, what'd you do regarding a John Patrick fine that makes you think that you're guilty?
Well, he was calling me the N-word, and I found this utility knife, and I took it out and I showed it to him.
Hold on, Mr. Peterson. Hold on. That's a different case. This is a case.
He said,
the guy that you slapped at jail. Remember?
no, he said hardback. He said,
That's
yeah,
the jail. Right?
I'm sorry. He was also calling me the N-word in the cell and all kind of derogatory names. So they coincidentally broke us out to go to court, and I went and hit him in the jaw.
You did that on purpose?
Yes.
At this point in the hearing, the court shifts from procedural questions to the factual basis of the plea, a critical step in any guilty plea proceeding. The defendant attempts to explain the incidents through allegations of racial slurs and threats, which may provide social or emotional context, but legally they do not automatically justify physical assault. Notice how the judge repeatedly narrows the discussion back to intent and conduct rather than emotion or retaliation. That distinction is important because courts are generally tasked with determining actions, not settling personal grievances. It also raises a broader question for viewers. When verbal provocation escalates tensions inside a jail environment, where should the line between explanation and accountability be drawn?
Now going to the case ending in 0322. On the date of March 13, 2026. Same location, Hogback Road, Field Township, Washington County, State of Michigan. What'd you do to a Thomas Walter Eugene Vasher?
Well, I was locking in the medical ward, and he went in 20 minutes. He was there, and then he went and knocked on the door. He told Miss Jackson, "You better move me before I F this guy up." And I was like, "Man, he talking about me?"
So,
And when he said that,
Your,
and then,
Your Honor, may I?
No, he's doing good. Go ahead.
so when he said that, I put the Sugar Ray on him, and he then here I am, Judge Simpson. You know, I should have.
So when you say you put the Sugar Ray on it, what do you mean by that?
You didn't see him coming. They was coming. He underestimated me.
Okay, but you hit him?
I hit him.
All right. You did that on purpose?
Yes.
Right. Sir, I do have to advise you between the time of fine session for your plea and time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Better say that or I'll put a Sugar Ray on. All right. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
May 13th.
May 13, 2026, 9 a.m.
Thank you, Your Honor.
All right.
I'll come see you soon, Walter, okay?
Thank you, sir.
That's it for me, Your Honor. Have a wonderful day.
Hey, I don't know why you wanted to stop him. He was
Trying to make.
I don't know what question you could have asked, but he did it himself. Okay.
This hearing highlights how quickly courtroom proceedings can move from routine legal procedure into revealing moments about human behavior, institutional pressure, and personal responsibility. While the defendant openly admitted to the assaults, the hearing also exposed underlying tensions inside the jail system, including claims of threats and derogatory language. Legally, the plea process focused on voluntary admissions and clear acknowledgement of wrongdoing, but socially, the case leaves viewers with larger questions about conflict, safety, and accountability behind bars. Do you think the court handled the hearing fairly? Or should more attention have been given to the circumstances surrounding these incidents? Share your perspective in the comments below, and if you value thoughtful, fact-based legal and political analysis, be sure to like, subscribe, and turn on notifications for more in-depth breakdowns.